Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer the title or ownership of probate assets to the beneficiaries of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. In the show tonight, we will learn the nuts and bolts involved in probating an estate in Florida for a Florida decedent. We will also review the role of the Florida court throughout the probate train ride, from the time you are legally qualified to act to when you wrap up the estate and distribute all the assets to the beneficiaries. And we will highlight some important duties and deadlines to keep in mind during the course of your journey. We are fortunate to have with us tonight a Florida attorney who will share her expertise and guidance on this topic. Our guest is the managing and founding partner at the Menendez Law Firm in Fort Lauderdale. She obtained her law degree from the State University of New York at Buffalo and her master's in taxation from Georgetown University Law Center. Before opening the doors of Menendez Law Firm, she worked for the Florida Department of Revenue, Deloitte and 2 CPAs, and the law firm of Holland and Knight. Her practice concentrates on tax, estate planning, probate, real estate, and corporate business law. Please welcome Florida attorney Nydia Menendez. Well, welcome, Nydia. Thank you so much for visiting with us tonight. First, I want to start with kind of an introduction. Tell me about what court actually oversees Florida probates.
Well, it's the circuit court. Every county has a circuit court, and that's the court that oversees probate.
And I guess, and how is the probate involved at the outset of probate?
So in order to open an administration, you do have to petition the court to get involved. And you do that simply by filing a petition. And in Florida, e-filing is enforced. So for attorneys, we must file the petition using the electronic portal.
Okay. And of course, once you get started, does the probate court stay involved with the probate process once you've been qualified?
Yes, you have to stay with the probate process from beginning to end. And the end will look different depending on the type of probate.
Now, I noticed when we were preparing, I noticed in my notes when we were preparing for the show that there are a lot of documents that are available online and so on to be used for the probate process. Can you share your thoughts about the pros and cons of using those documents?
So I guess for some people, the pros might be that the documents give you a template of how to follow and what it is that the court is looking for. The con is that every court, meaning every county, and sometimes it's on the county, judge by judge, have their own preferences. So you really have to know how to navigate the system in order to file probate in Florida.
Well, that's very interesting. That really is, it's an interesting sort of barrier for folks if they're not familiar with the landscape as far as the judges. Well, let's turn now to the different types of probates. Okay, so are there different types of Florida probates?
So there are primarily 3 different types: summary administration, formal administration, and ancillary administration.
All right, so let's start with the easiest one. I have some notes from you educating me about this when we prepared for this. What is a summary administration? What's involved with that?
Summary administration is when the value of the assets is under $75,000 or the decedent has passed away more than 2 years ago. So there's an inherent implied simplicity to this administration. And the big difference between that and formal, other than those 2 criteria, is the fact that no personal representative gets appointed in summary administration. You go to the court, you say the value of the assets is so-and-so, or decedent has passed away more than 2 years ago. These are all the backup documents, and there are many. And the distribution should be like this, and I've given notice, and you enter a proposed order.
Okay. So contrast that to I guess, as I understand, a more robust probate is the formal administration. Tell us about that.
Okay, yeah. So that would be the formal administration. And so you go to the court, you say, this is a list of the assets. Perhaps we don't know. We need a personal representative appointed, in part to do some fact finding or to administer the assets that are already known to exist. For example, real property, bank accounts, or what have you. So you will ask the court specifically to appoint a personal representative because it's implied that it's less than 2 years since the decedent passed away. You must also publish notice, serve known creditors, and get notices and proof of service from creditors, beneficiaries, and all interested parties.
Okay. Okay, so there we have basically two ways of handling the probate of an estate. So obviously when we're talking about estates, one of the first things we talk about is, well, is there a will? So if there is a will and it's in a safety deposit box, how do we get access to that? How do we obtain that will?
So if it's in a safety deposit box, you could have a copy of the will, and the bank, or the lessor of that box, is supposed to grant you access to inventory the contents of the safety deposit box. Or you could just do it by court order. But I think that it's really important to note that you don't necessarily need a court order to inventory the box, as long as you have a copy of the will and the personal representative or the attorney of the personal representative, which is kind of tricky, right? Because how do you have a personal representative? And the answer is as stated in the will.
Okay, so if we find a will in that safety deposit box, do I just take it with me and take it up to the court, or does the bank take control of that?
The bank takes control of that, and the bank deposits it in the court where the bank is cited, which may or may not be in the court where decedent, that has jurisdiction over decedent. So, and what I mean by that is that the court that has jurisdiction over decedent is the county where decedent resided. So it may not be the same court.
Okay. Now, if there is a will, what are the various options that we run into as far as being able to probate that will? Because sometimes they have a self-proving affidavit, sometimes they don't. Could you explain that a little bit, please?
Yeah, so a will must be signed in the presence of two witnesses, and the best way to make sure that that is properly done is a self-proving affidavit where you have a third party, the notary, that says, I saw so-and-so sign, and they all signed in the presence of each other.
Mm-hmm.
And that's known as a self-proving affidavit. And if that affidavit accompanies the will and it's a proper declaration, then the court accepts the will prima facie as being valid. When that self-proving affidavit is not included with the will or is somehow defective, for example, let's assume that the notary does not say how they confirm the identity, then you're going to have an issue, and the court will likely reject that as a valid affidavit unless you take additional steps to, quote unquote, cure the presumed error.
Okay. So I guess my understanding is that we could actually have a witness give an oath saying that they saw the person sign it. Is that something that's available?
Exactly, correct.
Okay. So we talked about that. So tell me exactly what is filed now. I want to get a formal probate. What are the things I have to file in order to get that process going?
So in order to start the probate, if there's a will, you have to file the original will and a certified copy of the death certificate and the petition. So those would be the minimum filing requirements to get it started. And there's a bunch of other requirements. Again, every court has their own different requirements. So for example, in Broward and in Dade, you would be required to file an affidavit of heirs. Each court having their own form that you must file. In other counties, the affidavit of error may not be required. So, but at a minimum, standard throughout the state is going to be the petition, the certified copy of the death certificate, the short form without cause of death, and if there's a will, then the original will.
Okay, so a lot of times people don't have wills, and so we end up having to do something called intestate, or a probate and intestate estate. What does intestate mean?
Intestate means exactly that, no will. Body parts remain intact, but there is no will. And so what happens is that the devise of property goes by the default laws of the state. The state has already decided how the decedent's property will be distributed.
Okay. And you still have to petition the court, even with the intestate estate, to start that process. Is that correct?
That is correct, which I think is one of the biggest surprises that clients express. Oh, but I had a will. What do you mean I have to go to court? So having a will is the ticket to go to court. You're just expressing what you want to be done with your assets, but it's going to be up to the courts to quote unquote retitle the ownership of the assets.
So what's the difference between an heir and a beneficiary? We hear those two terms, but they are different, are they not?
Oh, yes, inherently different. So an heir is the persons, if you would, that are that the law dictates are your heirs. So, for example, it would be the spouse, lineal descendants, etc. A beneficiary, on the other hand, is the person that you designate to be the person to receive your assets. So that's the beneficiary. Of course, an heir could be a beneficiary, but a beneficiary is not necessarily capable of being an heir.
Okay. Now, I guess one of the big things, I know we chatted about this when we were preparing for the show, but the big thing that's really important about having a will is you get to pick who's going to be your personal representative. Is that something that you really stress with clients?
Absolutely, absolutely. It's your voice, right? What is it that you want to happen with your stuff? And I think as the landscape of our lives, right, as that changes and families become less and less traditional, it is more and more important to have the voice of what it is that you want to happen with your affairs, because the laws remain very traditional. And so, for example, if you are in a same-sex relationship, or if you are in a relationship where just you're living together but you're not legally married, it's critical for everyone, especially when you're not in a traditional relationship.
Sure. Now, a lot of times when people get qualified, they really have a hard time figuring out and locating heirs or beneficiaries for that particular matter. What have you found to be the best way to kind of get that process going so we can actually understand and find who are supposed to receive these assets?
So for the most part, my clients do know where the heirs are, but in the few times when my clients have not known, then we use heir locator firms.
Okay, and we have certainly used that as well. Well, we get somebody qualified, whether it's an intestate estate or a testate estate. They're the personal representative. But what are some of the important duties that a PR has in administering an estate?
So a personal representative basically steps into the shoes of decedent to administer whatever the decedent left behind. So if the decedent left assets, or if the decedent left debts, those are the two main things that need to be administered. And that's what the personal representative has to do. The personal representative is in charge of making sure that that gets done. And the way to get that done is a lot of times it involves giving notice to these parties. So notifying the creditors, notifying the beneficiaries, and the heirs.
Okay, so I think the thing is here we're talking really about a formal probate now. So in a formal probate, do they have to file what's called an inventory?
Yes, they have to file an inventory. It has to be done within 120 days of being appointed. So deadlines, and if decedent is older than 55, then I'm sorry, I'm talking about that's the notice of creditor. So yes, the short answer to that is yes, an inventory has to be filed and served on the Florida Department of Revenue.
Now, now separate from that, is there a requirement to file an accounting to show everything you've received and everything you've dispersed, or can that be waived in some way?
Yes, there is a requirement to file an accounting at the end of every administration, and that accounting can be waived by the beneficiaries.
Okay. And do we have to prove that I actually have distributed assets to a beneficiary? Do I need to get a receipt of some kind that says they got it?
Oh, yeah. Every time that we have beneficiaries, we make sure we collect a receipt and we file those with the court.
Now we're going to start to talk about creditors, but I know that there's an obligation. Let's sort of turn the page. There's an obligation to notify creditors and to publish. Tell me a little bit about that publication requirement. How soon do I have to do it? You know, and what am I trying to accomplish by doing that?
So what you're trying, at the end of the day, a probate is basically administration of assets, right? And so what the court wants to make sure is that the assets are properly distributed, and that whoever is supposed to be getting the property, the assets of decedent, they receive that. At the same time, the court wants to ensure that creditors get paid from available assets. And so I make that distinction because not all assets are available to creditors. There are protected assets. So in order to ensure that creditors are paid, there are two main things that get done. Number one is publication of notice to creditors. So you must, a personal representative has an obligation to file publication of notice to creditors, and that requirement is so well respected by the courts that unless you file with the court proof of publication of notice to creditors, the court will not issue you the final order. So publication of notice to creditors is super important. And then the other step is serving known creditors. So when you serve known creditors, in the publication for notice to creditors, creditors have 60 days to file claims. When you serve known creditors, you cut that in half to 30 days. And that's it. You cut it in half and they can't come back. Whereas publication of notice to creditors, there's that ambivalence whether they can come back within 2 years. The door kind of always remains open. So using the publication of notice to creditors, which gets published in a newspaper, and serving known creditors, those are the two basic steps that personal representatives must do with regards to creditors.
So when a creditor, and that's very important. I think people have to, and there's a form of some kind that actually they can pull down from the court's website to give that notice?
No, not from the court's website, but when you go to the newspaper that typically is used for this in Florida, the Daily Business Review, they have their own form that you can just fill out.
Okay. Now, I'm a creditor. I get the notice. Where do I file my claim?
You must file the claim directly with the court. If you do not file the claim with the court, then you are waiving the opportunity to file claims. So oftentimes, not often, but whenever I have a creditor that has not filed a claim after the prescribed period, and months roll on by, and then I start to get collection notices, they're out of luck. They've been served and they had an obligation to file with the court. They can ask me as the attorney all day long and tell me about the debt that's owed to them, but they have missed the opportunity to file a proper claim.
Okay. Now, you mentioned briefly, I want to just touch on, there are some protected assets under Florida law that no creditor can get to. I know people, you always talk about the homestead being protected, but you want to share a couple of what those assets are that are protected?
Yeah, well, the main one is going to be the homestead. And then another one, common one is vehicles. I believe you can have up to 2 vehicles. Also prepaid college accounts that qualify. And there might be some retirement accounts that also qualify. Those are more iffy, so I always check with the statute to make sure we're within the corners of the law.
Okay. Now, we've been traveling on this probate train, as you and I have talked about this now over the last, 20 minutes or so. How do I wrap this estate up? What's the process to bring this to a conclusion so the court actually says I'm done?
Okay, so again, it's going to depend on the type of probate, but we've been talking about formal probate. So what you do in a formal probate is you petition for discharge, and that's where the court goes step by step. Have you done everything that you needed to do in this administration to get your order of discharge? And so everything means notices, filing the proof of service, and making sure that all debts, all claims have been paid or satisfactions have been obtained. So what you want is a petition for discharge, and you want that order of discharge, and the court will go through a very onerous process of making sure that all the requirements on the part of a personal representative have been completed.
Okay. Now, just so we can kind of give everybody a perspective, what's the typical time frame that we would expect a formal probate to run from the time I get qualified to when I get discharged?
Oh gosh, it really varies, and it's going to depend. But what I tell clients more and more is that it will be no less than 6 months. And I always make sure to clarify for the client that it could be longer. It likely will be, because it depends on many factors, including the fact that we are in court and we cannot control the court's calendar.
Of course, of course. Well, we have covered a lot of territory in a very short period of time, but I thought I'd ask you to share some final words of advice on steps for folks to take or pitfalls to avoid in undertaking a probate of a Florida estate.
Wow. So the biggest tip is plan, right? So that you can have a voice, and so that you can not leave a mess behind, because probate is expensive. It takes time. It's intrusive. It's a moment of grief, and now we attorneys are having to ask for all sorts of documentation. So I would say plan to avoid probate, because it is no fun. And of course, planning. We've talked a little bit about the will. So if you use a will, you're going to have a voice, but it's still going to go through probate. Having a trust and properly funding assets into the trust is one way. Or even with respect to real property, having proper deeds that convey the real property in a responsible manner, the way that you would want, are typical ways, very simple ways to avoid probate. So the one tip is plan, so that you can avoid probate, because it is avoidable.
Okay. Well, I want to, on behalf of the probate, we're really out of time, and I'm sorry to say that, because we could talk, I know, for another hour without even missing a beat. But on behalf of the Probate Nation, I want to thank you, Attorney Nydia Menendez from Fort Lauderdale, Florida, for taking the time to visit the Probate Nation, and for sharing with us both an overview of Florida probate law, as well as your advice on what to do and not to do. Valuable information, and really a great public service for those viewers confronted with a Florida estate to be probated for a Florida resident. So thank you very much for helping us out, learn about Florida probate.
My pleasure. Thank you for having me, and thank you for doing this. I think it's great.
You're very welcome. Without a doubt, probate can be complicated and confusing. In this show, our guest has given us an excellent introduction to the Florida probate process. Be sure to also check out all the useful guides, forms, and checklists available online from the Florida court websites that would be handling the probate you might be involved with. Remember that some courts have their own forms, so be sure to check the website of the court where you are probating the Florida estate. Collectively, these resources and the insights shared by our guests this evening should make your Florida probate train ride go a bit more smoothly. But I would be remiss if I did not emphasize the importance of consulting with a local Florida attorney about any probate you may need to initiate. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls for the uninformed while expediting the time you ride the Florida probate train. I hope you found the show helpful should you need to probate a Florida estate. And remember that replays of this show and all shows today can be viewed on the Probate Nation website. This brings us to the conclusion of our show. On behalf of the Probate Nation, thank you for visiting with us.